Hi, estate planning attorney Brian Barboza, and today I'm going to discuss what is the best way to utilize your IRAs or 401ks when creating your estate plan. Before we get started, if estate planning is something that you want to talk more about or want to explore your options, please feel free to give me a call or go to my website, barbozalaw.com, book an appointment to speak with me for free directly through the website. Okay, so what is the most effective method in incorporating your retirement plans into your estate plan? All right. Most of the time when people have assets, significant assets, for instance, their estate is worth more than $180,000, at least in California, they're going to create an estate plan that includes a trust. And most property, like real estate, brokerage accounts, bank statements, would be then transferred into that trust. However, retirement accounts like 401ks and IRAs, those cannot be transferred into the trust. So what has to happen when you're creating your estate plan is you're going to have to redo or revisit at least the designated beneficiaries for those accounts. So for instance, a 401k, when you opened it up, you more likely than not listed who would be a beneficiary of the money in that account when you pass away. And same with the IRA. So the issue is when you're creating your estate plan, you're going to amend those designated beneficiary forms. Generally, and this is just generally, not every situation is the same, married couples would usually name each other, the spouses, as the initial beneficiary, okay? And then if you did have a trust in your estate plan as a contingent beneficiary, sometimes you would then name the trust as a contingent beneficiary in the event your spouse predeceased you. Then what would happen is then if you passed away thereafter, the money in those accounts would then go into your trust, and then the trust would say who gets the money. So that's one method. The other method, again, generally your spouse would be named as the primary beneficiary, if that's how you want to set it up. And then you could also, instead of naming a trust, you could name other individuals you would specifically want to get the money in the event your spouse predeceased you, and then the money would go to those individuals when you eventually passed away. There are some pros and cons to doing it that way versus putting it in the trust, and vice versa. There's some pros and cons to putting it in a trust versus sending it to individuals. And those can get pretty complicated, and they can also include some tax issues. However, that's generally when you're trying to create your estate plan and you start dealing with your retirement accounts, you're going to have to change the designated beneficiary forms to capture your intent on what you want to happen to those funds when you pass away. So that's it. Retirement accounts do not get put in the trust. You need to amend the designated beneficiary forms to actually distribute the property to who you want it to go to after you pass away, or whether or not it goes to a trust or an individual. Okay, I hope you got something out of this video. Again, if you want to talk more about estate planning or explore your options, go to my website, barbozalaw.com, and you can book an appointment to speak with me for free through the website. I hope you enjoyed the video. I hope you got something out of it, and have a good rest of your day. Take care. Bye.